What the court basically says here is the decision to prosecute or not to prosecute is exclusively one of the executive branch, not judges. That's entirely in the hands of the Justice Department, and therefore he exceeded his authority in wanting to keep the case going. So it is a complete victory for Flynn. All that's left here is, in essence, returning it to the lower court to perform last rites.
Or maybe that's not all there is to it, because we thought previously that it was going to be the end of General Flynn's ordeal, yet it keeps going on. And I've been reading that some legal experts think there's a chance that Judge Sullivan will prolong the situation. We'll get to that in a little while. But first, Donald R. Hammond, Esquire, criminal defense hero. Let's summarize where we're at. You feeling okay? Is your health all right?
I'm good, Jeff. Excited to be back into court on several cases this week and getting great results for clients, and trying to track the news also and see what judges out there on the East Coast are trying to do to poor innocent men like Flynn, just as the judges here trying to do terrible things to my poor innocent clients.
Do the bailiffs take your temperature when you enter the court?
They do not. I have not had anybody at the courthouse take my temperature yet.
That is irresponsible. I may need to knock down a statue or something in protest. All right, so let's get to it. First of all, no technical explanation, but just for the layman, Don, General Flynn asked for a writ of mandamus. What does that mean, and is it rare or is it common?
It's relatively rare, but what you're asking the court to do is order either an administrative body, or in this case, a lower court, to do something. It's the sort of English term is a writ of mandate. So we're asking a higher court to mandate that the lower court do something. In this case, the government, the executive branch of government, had filed a petition to dismiss the case. And normally prosecutorial decisions as to whether to prosecute somebody or not to prosecute somebody, or to drop a case once it's filed, all of those decisions usually reside within the executive branch. So they filed a motion to dismiss this case. Judge Sullivan said, I don't know if I want to do that. He set it for a hearing out in July. So General Flynn's attorneys filed a petition for a writ of mandate or mandamus with the appellate court saying, would you please order this judge to dismiss this case? And they had oral argument, and the appellate court said, yeah, I think we'll go ahead and do that. So they have now ordered Judge Sullivan to dismiss the case, to grant the government's motion to dismiss. And that's where we are.
All right. So one of the key issues that they're screaming about is the Rule 48 leave of 48 requirement. So maybe you can explain in a minute what that means. But let's take a couple of excerpts from, it was a split decision, by the way. 3 judges on the appeals court ruled, and 2 Republican judges ruled in favor of dismissing the case, and the Obama judge dissented. So from the majority opinion, whatever the precise scope of Rule 48's leave of court requirement, this is plainly not the rare case where further judicial inquiry is warranted. To begin with, Flynn agrees with the government's motion to dismiss, and there has been no allegation that the motion reflects prosecutorial harassment. Additionally, the government's motion includes an extensive discussion of newly discovered evidence casting Flynn's guilt into doubt. And I tried to pick what seemed to be the most relevant portions. This is also from the majority opinion. A hearing cannot be used as an occasion to superintend the prosecution's charging decisions. And one more, the district court's orders appointing an amicus and scheduling the proposed hearing therefore constitute clear legal error. So another thing they were talking about is the presumption of regularity. And I take that to mean if the prosecution, or rather, the government says that they don't have a case, you just assume it is. You don't make them prove it. You give them the presumption of regularity. Is that pretty much what it is?
The presumption of regularity applies broadly to various government actions, things that executive agencies might do, things that prosecutorial arms might do. There's generally, it's a rebuttable presumption that what they're doing is, within their normal scope, and it's what they're supposed to be doing, or at least what they think they're supposed to be doing. So normally there's no reason to go look behind that. Now, it's a rebuttable presumption. So if there was somebody on the other side of the case that said, hey, this is not within the scope of what they are regularly doing, this is not what they're supposed to be doing, then we may be able to look behind it. But what's on the other side of this case is General Flynn and his attorneys saying, yes, we agree. Let's dismiss this thing. So as we've discussed before, I mean, the court's role is to decide controversies between parties. There's no controversy here. Everybody agrees the case should be dismissed. The judge, for some reason, just wants to, stick his head into it and, create a controversy that isn't there, or create his own controversy to decide. And that's not what judges are supposed to be doing.
The Obama judge and some of the anti-Trump legal experts who pontificate on TV and the internet are saying that the judge can act in the public interest. In other words, the idea is to have a hearing to make sure there was adequate protection of the public interest. Is there anything to that claim?
I don't mind that a hearing was set. I don't mind having a hearing on a motion. Whenever I file a motion, I expect there to be a hearing on it. I think that that's reasonable and within the scope of the judge's duties, is to have a hearing, listen to both sides, and make a decision. His discretion here would be very, very limited as to what he could actually do after that hearing, after hearing from both sides. When both sides show up and say, yeah, we think this is the right thing to do, we agree, please go ahead and grant this motion. There's just not a lot of wiggle room there for the judge. There are prior cases regarding Rule 48, which is the dismissal statute under the federal rules. And those prior cases say that a judge could deny this if there was a harassing purpose, where the government was going to dismiss a case without prejudice, which means they could refile it. And it looks like the government wants to keep playing this game to torture somebody and never let the legal ordeal come to an end. But that's simply not the case here. So I think Judge Sullivan would have very little discretion in terms of this hearing. But it doesn't bother me that he set a hearing. And in fact, I think that the appellate court was probably incorrect to grant this before there was actually a hearing. You should give the judge the opportunity to do the right thing before forcing his hand.
Right. Well, here's the dissenting, something from the dissenting judge. This is no mere about face. It is more akin to turning around an aircraft carrier. That sounds like melodramatic bullshit, basically, because the government gave its reasons, so I don't know what is so unusual about what's unusual is the malfeasance to which Flynn was subjected. It doesn't seem all that unusual to dismiss the case on that basis. So you're saying you don't have much of an objection to having a hearing, and part of the argument there is, well, as Judge Sullivan didn't order any discovery, he didn't issue any subpoenas. It's just about briefs and arguments. But isn't that kind of burdensome?
Well, that's very common. In any kind of a hearing, a judge isn't usually going to issue subpoenas or, request discovery. That's for the parties to do. If I file a motion and I want a police officer to come testify at the hearing, I'm going to issue a subpoena for that. If when I file a motion, I file what's called a memorandum of points and authorities to go with it. And that's my motion. That's the brief that goes with my motion explaining why I think it should be granted. If there's any evidence that I want to present, I'm going to bring that evidence. Here where, if I've already talked to the prosecutor and talked to the other side and they agree with me and they're not going to object, then there's very little reason to bring any kind of evidence to a hearing. Everybody agrees, Judge, please sign off on this. Happens all the time.
Well, it happens all the time when it hasn't been determined that the case should be dismissed. So what I'm saying is you say you have no problem with the hearing, but is there nothing to the argument that this would be too burdensome on Flynn and his counsel? I mean, they've already been brought through the ringer. And then there was well, all right, let me just have you answer that first before I bring up the next point.
No, it should be a 10 to 15 minute hearing. Hey, government, is everything in your brief true? And you have anything to add? No. General Flynn's counsel, do you have anything to add here? Anything else we should consider? Your Honor, we're in full agreement with the government's motion, and we would also like it to be granted, please. Unless the court has any specific questions, we'll submit on the moving papers. And I mean, that's how this could be a 90-second hearing, like mini hearings in court. And the judge says, okay, great. I don't see anything here. I think where the judge went wrong is appointing amicus and asking for some outside party to give briefing on something that's rather unrelated.
Well, there was nothing in the majority opinion that spoke to harm that Flynn would suffer. So you may have just given the explanation for that because it really wouldn't have been all that burdensome for them to respond. But they did say there would be harm to the government, meaning that they would be forced to reveal their internal deliberations and so forth. And that's not proper. And the dissenting judge poo-pooed that. And some of the anti-Trump lawyers are also saying, the other argument is that since the government didn't formally petition the court, it doesn't make sense to make any ruling based on harm to them. I mean, who cares about harm to them if they're not even the one filing the petition? But they did participate in oral argument. So what do you think about that?
Sure. I mean, they basically joined in the petition. So what we had at the lower court level was the government filed a motion and the defense basically joined in it and said, yes, we would also like that. It looked like the judge wasn't going to do that. He took a really weird step of appointing amicus to try to get other opinions on it. So the defense said, we don't think that's right. We're going to appeal this. And the government said, yeah, we agree with your appeal. So at the lower level, we had the defense jumping on the government's argument, jumping on their bandwagon. And then at the appellate court, we had the government jumping onto the defense's bandwagon to both argue for the same thing. So I think that's fine for the court to evaluate what prejudice might exist to anybody in this situation. It's not a lot. I mean, you're talking about attorney's time, at least one government attorney. You're talking about a defense attorney, at least one, going to the courthouse and waiting their turn for the case to be called, which could be a couple hours, depending on how busy that courtroom is and how the judge runs his calendar, to then have a 2-minute argument.
Right. But I'm not sure you answered my question. What I'm trying to get at is whether or not there's any validity to the claim that they shouldn't give any credence to whether or not the government was harmed because the government isn't the party that filed the petition. And this is, maybe you can help me understand this. This is the closest I could find to anything in the opinion about that. Here we invited the government to respond, and at argument, the government offered to file a petition at the court's request. So, Don, are we to infer that that's just the court's way of saying, well, don't bother, that's just a formality, the fact you're here and participating is enough? Is that what that means?
It is. So, I mean, the government agreed with the appeal that was filed. So they didn't file a response or anything. They showed up and argued their case at the hearing. I think that's fine. And there's no need for them to file anything. And I think it is appropriate for the court to consider, what prejudice might arise to any of the parties in the case.
Okay. So let's get to one of the other points you mentioned. You said you object to the court appointing an amicus counsel?
Yeah, I think that's mostly improper, certainly at the district court level. We see it at the circuit court level, the next level up, the federal appellate courts. And we see it at the U.S. Supreme Court fairly regularly that they're going to invite amici or amicus parties to file briefs. Those are friends of the court briefs related to various issues. But they've got to inform some controversy. In fact, there was a case sort of before this Flynn thing heated up again. There was a case out of the Ninth Circuit where the U.S. Supreme Court said, hey, knock that off. You don't get to, there's no controversy here. You don't get to appoint an amicus curiae to talk about it. Stop doing that. And then Judge Sullivan turned around and did it in this case.
Well, I think it's nonsense, but in fact, Sullivan did bring up perjury and contempt of court, and insofar as he did, let's analyze that part of it. Is it not true that judges can appoint counsel to go after people for perjury and contempt of court? And if they have the authority to appoint counsel to do that, would they not have lesser authority to appoint counsel just to get advice about whether or not to do that?
No, so the judge has no authority to file a perjury case or to find somebody guilty of perjury absent the executive branch of government filing a complaint or a charging document related to that charge. A court can unilaterally hold somebody in contempt of court for violating a court order or for refusing to do something that the judge orders, things like that. But none of that stuff was really on the table here, or should have been really on the table here.
Yeah, well, I think there is a conflation of the terms perjury and contempt of court, and I don't think it's my fault, or maybe I'm just not remembering every detail. But what I think Sullivan brought up was just perjury. But in this opinion I read, they were making references to contempt of court. And was that is that relevant at all in your mind?
I don't think that it is. I think perjury is a code section that would be violated. You've violated the terms of this code section that says thou shalt not lie under oath. That's a different thing. That would be prosecuted by the government. Now, a judge can hold somebody in contempt for any number of reasons, for not paying proper respect to the court, for showing up late if he wanted to, for lying to the court could be a reason, but who's going to prosecute that? The judge would have to make his own decision that has happened, and then what the appropriate sanction would be. And it would be highly unusual anyway. I mean,
right.
It's so rare. I'm in court every day, and it's so rare to see anybody held in contempt of court for anything, unless they've violated a restraining order or something that's really, pretty actionable.
So the Court of Appeals ordered Judge Sullivan to dismiss the case. Could the Court of Appeals have dismissed the case themselves rather than ordering Sullivan to do it? Or is that procedurally an impossibility?
I think they probably could, but I don't think that they should. And I think it would be very unusual for them to do that, especially at this stage where there hasn't been a lower court ruling. I think in this
difference and a practical.
Okay.
Go ahead. I'm sorry.
In this procedural posture, I'm actually not even sure that they could, because what was asked for was an order ordering the lower court to do something.
Okay.
What we prayed for was not for the appellate court to dismiss the case. That's not what the parties asked for. The parties asked for them to order the lower court to do something. That's what a writ of mandate is.
Right. Well, there's another aspect here. You know me, sometimes, I want to be in charge of the world, or at least the judiciary, and some things just make no sense at all to me. And I don't think that Judge Sullivan gave Sullivan any deadline. So how can you order somebody to do something if they don't have to do it by any particular time? How do you figure out whether or not the order has been obeyed?
Well, I think there's a presumption that a reasonableness limit would apply. So, I haven't actually seen whether Judge Sullivan is planning to go forward with his hearing in July. Was it July 17th or something was the hearing?
Hearing today, but he didn't dismiss the case.
They had a hearing today?
No, today he canceled the hearing that was scheduled.
Okay, I haven't seen that. So yeah, I think that the next thing
He did not dismiss the case. So that's still hanging in the air, whether or not he will ask the full Court of Appeals to consider, or whether I read that the court itself could decide to do that. And I also read there's a possibility of even going to the Supreme Court.
Sure. So the full appellate court would be called an en banc panel, which means the entire appellate court rather than this 3-judge panel. They could take this up for review, which would again be incredibly unusual, but we've seen a variety of very unusual things happening in this case. So, stand by. Judge Sullivan can ask for that. This panel could ask for that. I don't think that they would. I think that if anybody's going to ask for it, it would be Judge Sullivan. And then it's a matter of, they would probably decline to hear it, but it's another way of dragging this out.
Well, that's why I'm harping on the deadline. You say, well, a reasonable amount of time is the assumption.
Nothing.
Why not? Like, let's say you were on the appeals court and you made the decision they made, and this came up as you're chatting with your fellow judges, and somebody said, "Hey, why don't we give them a date by when to do that?" What would be the discussion in chambers that would lead somebody to say, "Nah, it would be better to just leave it up in the air"?
So one thing that you have to consider is the time deadlines to appeal this decision, to either have it transferred to an en banc panel or to file a petition for writ of certiorari to the United States Supreme Court. So you want to look at those time deadlines, and any deadline that you set can't be shorter than those as a practical matter. If he has 60 days to file his next appeal or whatever, then he has that time to do that before this decision even becomes final. So you'd want to set a deadline beyond that. Say you could set it as, within 10 days of this decision becoming final, then you must dismiss the case. I don't think there are usually deadlines included in these kinds of things.
So sort of facto deadline because of the appeal deadlines that exist apart from this.
Sure. So once this decision becomes final, if there are no further appeals, within 2 weeks, if it wasn't dismissed, I would be knocking on the appellate court door again saying, all right, he's ignoring you. Now we need sanctions. We want him to pay our legal fees, and we want to, go ahead and have the appellate court dismiss this thing because he's not listening.
Okay, so just one more time on what these options are, on what might happen henceforth. I think we said what they are, which is that the judge himself could ask for the full Court of Appeals to review it. The judges there could decide on their own, or there could be a petition to the Supreme Court. Correct? Those are the 3 possibilities, or there are other possibilities?
So those are the 3 possibilities that could prolong this thing. The 4th possibility, of course, is that Judge Sullivan could just dismiss the damn case and move on with his life.
Right. And what do you think is going to happen?
I hope that the Judge Sullivan will just dismiss this case in the next couple of days. I'm sure he's, talking to his attorneys, which is another baffling thing, that a judge has hired attorneys to represent him in this case. But, he's probably talking to them, trying to figure out, whether it's worth it to try to take it up, which I don't think it is. So I would expect in the next couple of days, we'll see a dismissal quietly entered on the docket.
Okay. So as I mentioned before, the news that broke today while you were busy fighting justice in the courts or downloading porn, whatever you were doing, what was that Flynn canceled the hearing that was scheduled. But he could still have a hearing if he wanted to, right? The court didn't tell him he can't have a hearing, did it?
So, well, no. I think you said Flynn canceled it. I think you meant Sullivan canceled it, right?
I did mean that. Sorry.
Okay. Yeah, no problem. So, yeah, he could hold a hearing on it still, I think, but he's limited. He's very limited as to what he can do at that hearing. He's even more limited now than he was before the defense brought the thing up on a writ of mandate. So, what's the point to having a hearing and dragging everybody into court at this point, except to make more of a media show? And, I don't know what Judge Sullivan's ambitions are or why he wants to carry this out and, drag it out even longer. But, he's very limited now.
He seems to be, to put it charitably, an obstinate creature. And he's just disinclined for whatever reason to dismiss the case. So I don't know.
And I'm sure he appreciates similar obstinance in people who appear in his courtroom. I'm sure he takes very kindly to that.
Yeah, right. So if you were Michael Flynn, would you uncork the champagne bottle or would you hold off?
I'm going to pull that cork halfway out and, and let it sit.
To really celebrate. All right.
Yeah, I would wait till the whole thing is over and, then figure out what he wants to do with the next chapter of his life. I mean, they say there's no such thing as bad press. He's certainly gotten a lot of notoriety out of this. So it'll be fascinating to see, which news network he lands on as a commentator and or which future administrations decide to hire him as an advisor.
All right. Well, let's keep tabs on the situation. It's a never-ending show, it seems, but maybe we're near the end of this. And thanks for enlightening us, as always. We'll talk again soon.
Happy to help. Thanks, Jeff. Have a good one.
Okay, you too.